acts termed gross misconduct are so serious in themselves or have such serious consequences that they may call for dismissal without notice for a first offence, but a fair disciplinary process should always be followed before dismissing for gross misconduct. So hopefully that's something that you'll take away from the session today. You'll see there that ACAS say, although the gross misconduct offence is so serious in nature, it doesn't warrant that a full process isn't required or a full investigation. Even if you're dealing with a gross misconduct dismissal, the full process should be carried out as you would for any other misconduct. So common examples of gross misconduct, these are things that will most likely be in your own policies, include things like theft, fraud, physical violence, serious negligence, or serious breach of health and safety regulations. So quite typically in your disciplinary policy, it will say, common examples of gross misconduct include but aren't limited to, and it will list various things. So these ones tend to be in, every kind of policy I see, but you can list specific examples of gross misconduct that might be specific to your organisation. If, for example, you're held to certain regulatory standards that are required, anything that's specific to the type of work you do in your business, you can tailor that list to include that example of gross misconduct. And again, what's considered gross misconduct can actually vary depending on a range of factors, and that's something we see come through in the case law. So, for example, what's considered gross misconduct for a senior manager might be different for, a more junior employee in the business. And as well, the nature of work carried out. If you're in a business that health and safety is extremely critical, and making a health and safety error could result in injury. You can imagine how that might be considered gross misconduct, but in other businesses, the danger, the implications of a health and safety breach might not be as severe. So all of these factors are relevant when you're making an assessment of whether or not it is gross misconduct, and you should consider all those kind of factors when you're assessing that. So I touched on this briefly. Sorry. That should be that sorted now. So I touched on this before, but the effect of a gross misconduct dismissal, it's not that no process is required. It basically means that you're entitled to summarily dismiss that employee. And what that means is that they're not entitled to any notice pay as part of that dismissal, but no process.
Just got a phone call for Alan Ross.
Sorry, can I just ask everyone to pop themselves on mute?
She's in hospital.
That should be us now. So yeah, as I was saying, the effect of a gross misconduct dismissal is not that no process or a shorter process is required. Even if the misconduct in question is, really serious and seems black and white, a full disciplinary process would be required. It just means that when you go through that process and at the very end, you're making a termination. If it was a dismissal that followed a series of warnings, that employee would be owed their notice pay. But if it's a gross misconduct offence that you're dismissing for, no notice pay would be required. And another thing that we have seen been asked before is that at the very end of that process, when you're looking to make the dismissal and you're not paying notice because it's gross misconduct, whether or not the employee would be entitled to other contractual payments. So things like, pay for hours that they've worked in their owed or accrued but untaken holiday pay. And even though the effect of that gross misconduct dismissal means they wouldn't be eligible for any notice pay, they would still be entitled to those other contractual payments. And just a couple of key differences. If you're dealing with a disciplinary process for misconduct, against, more severe gross misconduct. So if you're going through a disciplinary process and it's just surrounding misconduct, normally you would follow your disciplinary process, which would have a staged series of warnings. So it might start on a verbal warning or a first written warning. And if that's still live, it'll escalate up. But if it's gross misconduct, you would normally be coming in at that dismissal level, so you can go straight to dismissal following the disciplinary process. And again, if it's a general misconduct dismissal, then the notice would be payable. So that's the key differences. So just having a think about the disciplinary process, and again, today's just a short refresher in gross misconduct, so we'll not have time to go through this in full at all. But at the end, I've included a slide just with useful resources that you can access, just if you want to have a general refresher on the disciplinary process. But even if it's gross misconduct, the process is the same as if you're dealing with any other type of misconduct. You would still be required to fully investigate the gross misconduct offence. Once you've investigated it, if there is a case to answer to, it would proceed to a disciplinary hearing where the employee would need to have the opportunity to fully state their case in relation to the gross misconduct offence. And at that hearing, they would have the right to be accompanied by a work colleague or a trade union official. Once they've had the outcome, once you've had the hearing, the manager who's hearing the disciplinary stage would need to consider the case, we'll have a look at the different types they should consider as part of that, and issue an outcome. And as part of the disciplinary process as well, the employee will always have the ability to appeal that outcome from the disciplinary hearing, and that should be heard by usually a more senior manager at appeal stage. And the process is almost repeated there, where you'll hear the grounds of appeal, but you'll have another meeting, you'll have an appeal hearing where you go through the grounds of appeal, and then at the end issue another outcome as to whether or not you uphold or reject the appeal. So you'll see there that even when you're dealing with gross misconduct, the process that you follow, it still has to comply with the ACAS code. And even though that you're summarily dismissing potentially because it's gross misconduct, no part of the process is dispensed as a result of that. Another thing that I often see in a lot of policies is just that if it's a, potentially a gross misconduct offence, that the employee will automatically be suspended. So it might have one along the lines of, if you're suspended for a potential gross misconduct offence, you'll be suspended pending the investigation. So that might be because there's been some sort of violence in the workplace, and potential theft or fraud. So these are all reasons why you might consider suspending. Violence, there could be a risk of further violence outbreaking in the workplace. So from a health and safety perspective, you might need to take them out while you do the process. Theft and fraud, I suppose the risk there is that if they're not suspended, they could either continue with that or do things to tamper with the investigation and cover that up. But there's actually been kind of new ACAS guidance earlier on the year on suspending, and that would kick in even if you're dealing with gross misconduct. And what that says is that the act of suspension, it shouldn't be just automatic. So there shouldn't be an automatic, this is gross misconduct, you'll now be suspended. The guidance is drafted based on the impact suspension can have on an employee's mental health. So what they say is that before you make the act of suspension, you should consider whether or not you need to suspend and consider actions short of suspension. So that might be considering things like, can you have that person do a specific task with restricted access to the systems that are causing the harm? Or if it's an instance of violence, and, the two people involved work from home, and that removes the risk without suspending. So it might be that you consider all these actions short of suspension, and you still find that it's appropriate to suspend, and that's okay. But it's just good to be able to demonstrate that you've made that step and you've not just suspended automatically, you've had to think through your rationale for making the suspension. And that would apply even if it's a gross misconduct offence. Keep it as short as possible. So just, as long as reasonably necessary for you to conduct the adequate investigation. And on the last point is considering mental health support. So that's another kind of key theme in the new ACAS guidance, is that those who are suspended, at the point of investigation, they may not have committed the gross misconduct offence, but the act of separating them and taking them out of the business can have a detrimental impact on mental health. So it's just worth factoring into your kind of suspension letter and letting them know any employee assistance programmes, any support you can think of through that time should be included as well. So I've looked at gross misconduct as a concept, kind of established as well that, you'd follow the same process, disciplinary process for gross misconduct as you would normal misconduct. But it's also worth highlighting the kind of legal claims that an employee might raise if there's any issues with gross misconduct. So the first that I'll take you through is unfair dismissal. And I just wanted to highlight with this that in an unfair dismissal claim, whether the employee has been dismissed for normal misconduct or gross misconduct, the same test applies. So, the tribunal doesn't deal with it differently because it's gross misconduct. They'll still use the same legal tests at tribunal, and I've put them down below. So, the employer believes the employee to be guilty of that misconduct. The employer had reasonable grounds for believing that the employee was guilty of the misconduct, and at the time it carried out as much investigation as was reasonable. So you'll see there that is the test applied to all conduct dismissals. So it doesn't distinguish, this is the way we'll look at gross misconduct, this is the way we'll look at normal misconduct. They'll use that same test. That might mean that if it's a gross misconduct offence, they might factor it in when thinking about how much investigation was reasonable. So it might factor in there that if it's a gross misconduct offence, you might have more people to speak to, more evidence to gather because of the seriousness, but it is the same legal test that they would apply. There's no real difference. And they'll apply the other test that your decision to dismiss must be within the band of reasonable responses that a reasonable employer should make. So, your decision to dismiss must be reasonable. It can't be, so different from what a reasonable employer would decide to do. And I think the last one's really important in the context of gross misconduct, just that in an unfair dismissal claim, the tribunal will expect you to consider mitigating circumstances. So quite often if you're dealing with a gross misconduct offence, you've had your disciplinary hearing and you could be the manager deciding or considering whether to dismiss. And quite often in your policy it will say, if the conduct is on that list of gross misconduct offences, so violence, something like that, you can be very minded of that equals dismissal. But in an unfair dismissal claim, the tribunal will expect you to consider mitigating circumstances. So if in that hearing the employee puts forth that they've been dealing with really traumatic and emotional time at home, or say it's drug and alcohol, but this drug and alcohol related gross misconduct offence, but that employee's disclosed in the past that they struggle with addiction issues, all of this would be considered mitigating circumstances that you should consider. So essentially consider, although this would normally be a dismissal, do these mitigating circumstances warrant me changing this to say a final written warning. Other things might be, is this a first time offence? Do they have long service with you? So even though it's gross misconduct, which would take your mind to dismissal, you should still at the end, when considering what sanction to give, consider whether the mitigating circumstances would warrant, something short of dismissal. And again, it might be that you have considered it. You did consider that the employee was having a bad day. But even in light of that, it was so serious that you still need to dismiss. And if that's the case, it would just be a case of putting that down in your outcome letter and making it clear in writing that you did consider it, but even though you considered the mitigating circumstances, you still feel dismissal is appropriate. And then the next claim is wrongful dismissal. One I see less than unfair dismissal, but it's very relevant in the context of gross misconduct. And it's an interesting one because there's no length of service requirement in this claim. Someone can claim wrongful dismissal where there's a dismissal and breach of contract. So where this kicks in can be if you dismiss someone for gross misconduct and don't pay them the notice. So what they might do is say that they've been wrongfully dismissed and make a wrongful dismissal claim to the employment tribunal. And what they'll claim is that the offence they were dismissed for, wasn't gross misconduct, so therefore notice should have been paid. Because as we covered earlier, if it's a dismissal for normal misconduct, the notice would be payable. So really, we're looking at notice pay in this context. So if this claim would be raised, the tribunal would assess whether or not the misconduct they were dismissed for was sufficient to be classified as a repudiatory breach of contract, and that would be a question of fact. So really just looking at the full context of the situation to assess whether or not the conduct that was the gross misconduct in question that the employee was dismissed for was sufficient to be, hit that bar of being a breach of contract. And that's often like the kind of breach of trust and confidence between them. So in this context, investigation's key. So just making sure that you've done enough investigation to show that you're correct in your assessment that this is gross misconduct rather than misconduct. And another interesting one is that a dismissal can be wrongful but not unfair. So it might be that if you have a claim for both of these, the tribunal can apply the test we just looked at for fairness, and you can procedurally have met all the requirements in the ACAS code, but at the same time, they might make this assessment that they're owed the notice pay, that it was misconduct rather than gross misconduct. So we do see this less, and it's probably a lower risk claim because we're just, even if you were to lose this wrongful dismissal claim, we're just looking at because it's a dismissal and breach of contract, we're just looking really at that notice pay. So that could be a week, a month's pay. So a lower risk claim that we do see less of, but relevant in the context of gross misconduct. And then just to finish it off, because I appreciate this is a big topic, but a very short snippet just of some key points today. So some useful resources if you want to kind of brush up on your disciplinary process knowledge. A good starting point if you're a Scottish Engineering member would be our employment guide. So if you've used that before, you'll know it's written in user-friendly language, and we have a full section that takes you through all this in detail. And then the second one being the ACAS code and disciplinary and grievance procedures, which again is written in user-friendly language and good to get familiar with because that's a statutory code, so we need to comply with that to comply with the law. And then another good one is just your own internal disciplinary procedure. So it's good to go through, be familiar with that, have a look at the list of gross misconduct offences on it, and see whether you think they need tweaked, if they're relevant, if there's anyone specific to your business that should be on that list. So another good starting point as well. And we've got time for questions. If anyone has a question, feel free to just pop your camera off and ask, or pop it in the chat if you're more comfortable doing it that way.